Welcome back to our third lecture relating to Module 2. I apologize for cutting Lecture 2 short. I had intended to go on, but something unexpected came up. So we were talking about Sarbanes-Oxley and the fact that this provides protections, and again, the focus of the protection is for the public at large so that they can get information from the whistleblowers that will help make sure that the company is well managed. This law was in response to the Enron and WorldCom scandals, as well as a few others that perhaps didn't grab as many headlines. And the idea here is that the public was harmed because of these accounting scandals, and if whistleblowers had been able to bring that to the attention of the regulatory agencies, then perhaps the problem would have been resolved in a way that wouldn't have caused these companies to fail. So the focus isn't so much on protecting the employees as protecting the general public, but the whistleblowing employees are the beneficiaries of the protection, so they definitely do get protection as a result of that. And we also have other federal laws that give a specific subject matter protection. SOX is focused on accounting issues, but you can see there are other laws relating to environmental issues especially. Now we're going to talk about a case. This is a Supreme Court case, Garcetti. Y'all don't know Garcetti probably, or y'all may know him as the mayor of Los Angeles, but his father, I think Gil Garcetti, was the district attorney for many years in Los Angeles, so kind of a larger than life kind of fella. Anyway, there was on his staff an attorney, Richard Ceballos, who was a deputy district attorney. Anyway, he found some irregularities in the prosecution of the case. He felt that one of the affidavits that was being relied upon in the prosecution actually included false information, and he wanted it to be removed from the case. The DA's office didn't agree with him, and so he escalated it to the judge, and obviously that did not make him a very popular person in the DA's office. The judge did not agree with Ceballos' interpretation of the circumstances, and so the document continued to be used in evidence. Ceballos felt that after this incident that he felt he was being a whistleblower, he was given various negative repercussions, and this escalated. So he sued, and this escalated to the U.S. Supreme Court. And the U.S. Supreme Court said that, yes, Ceballos has First Amendment rights, but not while he's doing his job as a public employee. And so the fact that he did share information about this wasn't a protected activity, as it would have been if he had been talking generally about a matter. Let's say instead of being a district attorney, he had been a garbage collector, and he heard about this inappropriate action. Well, and he pursued that and contacted the judge to hopefully get that resolved. Well, when he would go to the judge, he would not be acting in his official capacity, because garbage collectors don't have the job of being district attorneys, and so therefore he would have enjoyed his First Amendment protections in that situation. The city of Los Angeles would not have been able to fire him from his garbage collecting responsibilities. But because the nature of what he was speaking out about was integral to his job, then he did not have First Amendment rights under those circumstances. Again, this case is not an important one for you to know, because this is dealing with public employment. No one would have argued that if Ceballos worked for a private company, that he would have the right under those circumstances to be not subject to any kind of retaliation for having complained about how his manager was conducting an investigation or something along those lines. So Ceballos had worked as a private attorney in a law department. He definitely wouldn't have enjoyed First Amendment protections there. And of course, in this case, he didn't enjoy those protections in his public position either. So we've talked about The policy situation, we talked about the whistleblower situation. These both are exceptions to the employment at will doctrine. Now we're going to consider the torts scenario. So what is a tort? This is an important vocabulary word, not so much for this course, but we have a whole course in the program, LGLA 2303, that is all about torts and personal injury law. And torts is just a personal injury type situation, so it's kind of redundant, a name for the course. So what is a tort? It's a violation of duty other than one owed when the parties have a contract. This is about the biggest non-definition ever. Remember I said in an earlier presentation about how definitions are often circular. We talked about that with respect to the employee definition. Well, this is another one. What is a duty? What is a violation of the duty? And it kind of basically says this exists when it doesn't fall into the other category of contract. And again, this is just such a basic term to the law that just like you can't define the word red in a way that's going to make sense to somebody who doesn't speak English or doesn't know the word red in English, you can't define the word tort really without, it's such a basic concept, so it suffers from the same problems. Here are some examples of torts though that may help give you a little bit more of a point of reference. You can have a tort of extreme and outrageous conduct. When somebody does something really, really shocking to someone else, that can fall into this category. You can have an intentional infliction of emotional distress claim. When somebody intentionally hurts the feelings of another. If I were to say to you, for example, oh, I just got a call. Your mom was in a terrible car accident. She's not expected to live. And of course, you're immediately like, oh my gosh, this is so horrible. You're panicking. And then I say, April Fools. Well, that type of thing would be a case of possibly intentional infliction of emotional distress. The tort of defamation is something most of us know something about. They're arguing we have three elements here, so we need to have all three in order to satisfy this particular definition. And we're talking about an employment context. Obviously, you can have defamation in a context that isn't employment related. But in the employment related context, the employer has to make a false negative statement about the employee. That statement has to be heard by a third party. Usually this is going to be a potential other employer or his current employer. But it could be somebody else. But it's not that the employer is just saying it to the employee. That wouldn't be defamation. And of course, that communication has to harm the employee in some way. Maybe the employee is fired from his new job, or maybe he isn't hired into that new job. So these are the three elements. And then a fourth example of a tort, and there are literally dozens of torts out there, so this is just a partial list, is wrongful invasion of privacy. We have a separate module about the topic of privacy, so I'm not going to spend much time on that one today. Let's look at an example of this. So Mary resigns from her place of employment. Her boss tells the other workers, Mary's been fired because she came to work drunk. The boss also tells that to a place that is calling for a reference check and tells her, oh yeah, we fired Mary because she was drunk. But in fact, Bob knows that's not a true statement. First of all, she wasn't fired. Second of all, there was no evidence that she was at work drunk. If Wallaby's department store decides not to hire her after that reference, then Mary can also prove that she suffered a harm. Now, one thing to keep in mind about defamatory statements is they have to be false. If Mary actually had been fired for being drunk, then there is no defamation. Or let's say Wallaby's didn't believe Bob when he said she was fired for being drunk and went ahead and hired her anyway. Well, then you don't have any harm to Mary. Possibly reputational harm, but there's no economic harm. So you have to have all three elements to be satisfied. So you can have all categories of quote-unquote employees sue under a tortious theory. It can be an applicant, it can be an employee, it can be a former employee. Another thing to keep in mind is torts are civil wrongs. They're not criminal wrongs. many behavior that might be criminal can also be civil. So just because it's civil doesn't mean you can't file a criminal charge against that person. For example, some outrageous conduct could be considered criminal. For example, if I were to punch you in the nose, that would be a battery situation. It would also be a tort. Upon not outrageous conduct, it would probably be the tort of battery. So that the action battery can be a civil matter or a criminal matter. So just because it's a civil claim under tort law doesn't also mean it can't be a criminal claim. So torts can be intentional, and the examples I use here are intentional things, or it can be accidental. Car accidents, for example, are torts. It's pretty rare that somebody intentionally causes a car accident, but still the fact remains that whoever caused it is legally responsible for that. And of course, in the whole area of torts, we have that doctrine of respondeat superior, also vicarious liability. And those concepts apply whether we're talking about the employment context or not. So I'm not going to spend more time on that. The Wagner case is kind of interesting, even though it's out of Texas. You can see it's from the College Station area. This case is kind of interesting in several different respects. It's kind of interesting sociologically, but from a legal standpoint, what happened was Professor Wagner was a whistleblower, and his claims ended up being true about a colleague of his. Nevertheless, he was mistreated, or maybe that's loaded. He was denied the continuation of his employment at Texas A&M, and so Wagner sued, claiming that A&M intentionally inflicted emotional distress and defamed him. And unfortunately, Wagner lost. He said that the school's conduct towards him was not extreme and outrageous, even though here he is trying to do the right thing, trying to report misconduct, and his reputation is pretty much shredded, and he loses his job. Sounds pretty extreme and outrageous to me, but again, the takeaway here is when we talk about in Texas, employers taking negative actions against employees, the bar is really, really high. Employers can get away with lots of stuff. As long as it's not motivated by something that is statutory barred, most of the time, even when the employer is misbehaving, it's not going to result in the employee winning. Let's look at retaliation claims. This is in some senses a little bit similar to whistleblower claims. And a retaliation claim arises when somebody has been the victim of or is exercising some statutory right. A lot of times that is that they are reporting being the victim of discrimination, or they're reporting that somebody else in their work area has been the victim of discrimination or harassment. So here we have our definition: retaliatory discharge, terminations in response to an employee exercising rights protected by law. And again, this usually arises when somebody complains about some type of discrimination. And statutes do protect people under those circumstances. So if we have a statute that applies, we would look to the statute. We wouldn't look to this kind of common law notion. But if we don't have a statute to rely upon, in Texas, it's going to be a little bit tough proving a retaliatory discharge claim that would entitle the person to reinstatement. Now, of course, if there is some kind of state, if we're talking about if we're looking at this from a constitutional perspective, we need to have state action. Our constitutional rights all are designed to protect us from the state. And when I say the state, I mean the government. It can be the state, the local, the federal government. The idea is that we need protections from the government. There aren't constitutional protections that protect me from my neighbor or from a corporation or something along those lines, because those are private actors. So it's impossible for a corporation to violate my constitutional rights, even if they kill me. Certainly they've committed a crime, that's a bad thing, but they can't violate the Constitution because the Constitution isn't interested. It doesn't address the topic of private entities and their relationships to each other. So if I work for a private sector, well, let's say I'm married, I work in the private sector. I am politically active. I decide to protest something that our government is doing. My boss happens to have a different political perspective, and he wants to fire me for that. He doesn't want to be around or have employees who have that perspective. My boss can absolutely fire me for that. There is no protection for a political point of view. Now, of course, if I work for the federal government or the state government, that would be unlawful. But working in the private sector is perfectly fine for my employer to end my employment. So now we've covered the 4 general categories of bad faith or malicious prosecution. So these are 4 categories within this larger category. And now you can see we've covered our first 2 topics. These again are exceptions to at-will employment. We talked about statutory exceptions here. We didn't talk about it very much, but we will talk about it later in the course. Now we talked about that public policy category. Now we're going to talk about implied contract terms. If you haven't yet taken contract law, much of what I'm going to be talking about here is stuff that you will learn in that course. And we do talk about the topic of 1351 about implied contracts. But I'll introduce a little bit of that topic to you right now. One thing to remember as we're looking at this is that this is a loser argument in Texas. I'm not going to lie to you. Some jurisdictions it'll work. For example, Illinois and South Carolina and very possibly California, this would be a pretty likely area where you may be able to make some hay if you're the plaintiff. But it's hard to imagine it working very well in Texas at all. So what is an implied contract? So here we have another term in red that you're going to want to add to your Quizlet, and here is a definition. An implied contract is exactly what it suggests. It's a contract that is implied. It's not expressed, but it's created by words or the conducts of the people involved. When I go to Walmart and I put things on the conveyor belt, I don't say to the sales clerk, I would like to enter into a contract with Walmart to purchase these items for these specified prices. As you are an agent for Walmart Corporation, I am assuming that you will be entering into this contract on its behalf. Am I correct? The sales clerk would be calling security on me at this point. I've got a crazy lady here, right? That's not how we conduct those types of transactions. But even though I'm not saying contractual language, we all understand, the sales clerk understands, and I understand, and everybody else understands that once I put the items on the conveyor belt, I want to buy them. And so that's an example of an implied contract. So implied contracts are perfectly valid things. They're lovely things. We get into them all day long. And they can have some relevance in the context of employment law. But I'm going to be honest with you. Employment law, at least in Texas, is not a fertile ground for implied contracts. So what are some ways that we stumble into implied contracts, especially in other states? Well, one way is through some type of employee handbook. Many companies, especially larger companies, have some handbooks that kind of talk about kind of happy thoughts about how we're all one family. Oh, we're going to work together. Oh, we're going to treat you right. All that happy talk, right? And then you get fired for no very good reason, and you say, but what about all that lovely kumbaya language in the handbook? Well, in Texas, the court would say, get over it. It's kumbaya language. Nobody takes that seriously. You shouldn't have. You're an idiot. I'm exaggerating, but that would be the takeaway. But in some states, language, especially if it's pretty specific, that says things like, we will use progressive discipline, we will only use just cause to dismiss you. Language like that can create a greater exception to the employment of law than it otherwise would. So let's consider Bob's situation. So Bob is a salesperson. He seems to be doing great in his job. When he was hired, he was told, during his interview, he was told, how his wage structure would work and that he would receive various commissions if he completed certain transactions. He hasn't been getting those commissions. Under those situations, he absolutely can file a claim for breach of implied contract. In Texas, you'd probably file a payday claim under those circumstances. And this type of claim actually would work in Texas if the pay structure doesn't have to be formalized in a written document. If you've been told you're going to be paid X way, you need to be paid that way until you're told there's going to be another formula. Now, the employer can change the formula at any time, but whatever the changes are can't go into effect until it's been communicated. Because the idea is, when I hear that my commission is being cut from 10% to 8%, maybe I quit at that moment. I'm certainly going to be entitled to my 10% up until the second that I was told about the change. So this is one area that we would see Texas law would honor that contract, if I can prove it. Now, of course, Bob's boss may deny that he ever said those things, so there could be an evidentiary problem. So here are some examples where you might see a retaliation claim arising. If the employee points out some of these types of crimes or misconduct by the managers. As you can see, many of these are going to be covered by statute, certainly wage and hour violations. So in that situation, we don't need to worry about an implied contract scenario, because we would have this category to rely upon. This is always better. If you've got a statute to go on, you're not going to be thinking about contract law. Contract law is common law. You're going to want to rely upon that clear, crisp statute. You only fall on implied contract if you don't have anything better, right? So let's go now to the idea of the implied covenant of good faith and fair dealings. This is a California idea, so if you happen to have clients in California, this is something that may well be useful. It's an idea. Many of our legal innovations start in California, and sometimes they take off and sweep the nation. Comparative negligence is an example of that. That's something you learn about in torts. But sometimes they fizzle in California. This is probably one of those ideas that fizzled more than prospered. A few other states have latched onto it, but Texas definitely hasn't. And the California case that talks about this is Foley. Since it doesn't apply in Texas, well, we won't talk about Foley yet. So let's look at a vocabulary term. We have this covenant of good faith and fair dealings. So you'll want to, again, add this to your vocabulary list. It's an implied contractual obligation. And this, by the way, isn't controversial. This is a true thing. It is implied in all or virtually all contracts. That the idea is that people who are entering into a contract are going to treat each other fairly. It doesn't mean you don't try to negotiate the best price, but you're not going to lie to the person. You're not going to, for example, if I'm trying to sell my car, I'm not going to roll back my odometer, or I'm not going to lie to you about the repairs that I've had done on the car. Those would be violations of the covenant of good faith and fair dealing. So the covenant itself is not super controversial. It's implied into most contracts, and it requires both parties to act in good faith in the fulfillment of the reasonable contractual duties. Now, whether it is implied into employment contracts is the controversial thing. This covenant in the employment contracts, again, is construed narrowly. You can see if you construe this broadly, it could consume the whole at-will employment doctrine. And people, or at least our judges this time, don't want that to happen. So let's consider this situation. Bob is an employee. Per his work agreement, his monthly income was supplemented by substantial commissions that the company promised to pay him. He's been working on this big deal for 5 months. It's almost closed. He's done 95% of the legwork, and he's fired. After he leaves, the deal closes. Bob comes out and says, I ought to get my commission on that. But according to the terms of his agreement, he had to be employed by the company on the day the deal closed. Well, the only reason he wasn't employed by the company is he was fired. And he strongly suspects that he was fired so that the company wouldn't have to pay him his commission. So you can see how that's a pretty dastardly company under those circumstances. In California, this would be a winning argument, very possibly, if Bob could prove all those things. In Texas, it's a more difficult thing. If the contract actually says you have to be employed on that date, I think that the court would say, no, Bob, you weren't. You didn't satisfy the conditions in the contract. Bob, you should negotiate your contract a little bit better. This is that Foley case I was talking about. As you can see, it's a California Supreme Court case, so it doesn't really apply to our jurisdiction. Obviously, the California Supreme Court's authority ends at its borders. I'm not going to go through this case because, again, it doesn't apply to us. But in this case, Foley was, according at least to his take on the situation, was pretty mistreated and ultimately left the employee of his employer, Interactive Data Corporation. The California Supreme Court did allow Foley to continue with his contract claim that he was saying that he was told, he had an oral contract, that he could only be dismissed if there were good cause, and he was saying there wasn't good cause to dismiss him. But the California Supreme Court also said that he can't advance a tort claim under contract law. You know, we talked about torts in an earlier section, and we talked about that the definition we had for torts was something other than contracts, right? That was an amazing definition, wasn't it? So helpful. A violation of a duty other than one owed when the parties have a contract. And the general rule, even as the general rule in California, but certainly the general rule elsewhere, is that if you have a contract, you can't sue under a tort theory. You can sue under the contract theory, but not the tort theory. And so the idea that you can also sue asserting a tort claim when all your claims are contract claims is, it's not surprising this was denied. The reason you can't sue under a tort theory is that contract theories are limited to your actual damages. But tort theories, there is the potential to get punitive damages. And courts really don't want to open up contract claims for punitive damages. So that's kind of the subtext behind this. So if you have a contract claim, you need to sue in contract. And that's what Foley's being allowed to do. He's being allowed to advance his contract claim that he can only be fired for good cause. But since he has a contract claim, potentially, he can't have the tort claim. And here, California law would not recognize the tort of tortious breach of the implied covenant of good faith and fair dealing. So that's the long take on it. But again, you don't need to know this case. This is not the law in Texas. And even in California, they've backed away from some of this pretty extreme erosion of employment at will ideas. And so even in California nowadays, if the employer emphasizes the at-will nature of the employment relationship, these types of implied covenants aren't going to be given much emphasis, even in California. And so we've talked again about the statutory situation, the public policy situation, implied contracts, and the implied covenant of good faith and fair dealing, all of these being exceptions to the at-will employment doctrine. And again, keep in mind, the doctrine is huge. These are just small little exceptions. The vast majority of employment decisions that an employer makes aren't touched by any of these categories. We have one more to talk about, and that is the situation of promissory estoppel. This is another, oftentimes called quasi-contract theory. So let's look at that. Then we have another definition, so be sure to note this. Our promissory estoppel arises when the employer makes a promise upon which the worker reasonably rise to the worker's detriment. So again, we have kind of three ingredients here. The employer or potential employer makes a promise. The worker or applicant relies upon the promise, and his reliance is reasonable. You know, it wasn't a ridiculous promise that when you hear it, you know, well, that's never going to happen. It was reasonable to believe the employer. And as a result of that reliance, the employer is harmed. That's what employment-related promissory estoppel is about. One way to remember this is you see in the word estoppel, you see the word stop. So what this means is when you make a promise, when you're the employer and you make a promise, you are stopped from not fulfilling the promise in the employment context. At least if this doctrine applies, that's how you can remember the name. So the promisor is stopped from not honoring the promise when the worker has relied upon the promise. So in some jurisdictions, this is a winning argument, and it can win in Texas, but it's really important that you have a very definite promise and that it's really kind of nailed down in your position. This is probably not ordinarily what you want to do in Texas. You're probably, again, this is where your most profitable exception is going to be to the at-will doctrine in Texas. But I'm not going to foreclose the possibility that this could win. Let me give you an example of promissory estoppel. Imagine for a second that you apply for a job and you are told you are living in Dallas, so the job is in Seattle, and you're told that you should report to work on September 17th, and that the job that you have is several steps up the hierarchy than the job that you are currently in. You're going to earn 50% more, and it's just all around a very, very exciting opportunity. You quit your job that you currently have, you end your lease, you pack up all of your stuff, you hire a moving van, and you move to Seattle. You sign a lease for an apartment in Seattle, and you show up on that first day at work. You come in and they say, oh, we changed our minds. You can work today. We'll pay you for today, but after today, we won't be renewing your contract for a second day. Thanks so much for coming, but we aren't interested in your services anymore. And you're thinking to yourself, I had a good job. I paid all this money to get here. I am tied to this lease here in a city where I don't know anyone. How am I going to handle this? That is kind of the classic example of promissory estoppel. The employer can say, well, you were employed at will. You didn't have an employment contract. Every minute of the employment relationship requires that both parties decide to continue it for another minute. We've decided to discontinue it after 1 day, or maybe after 1 hour, or maybe after 1 minute. We're allowed to change our minds. Well, yes, but their argument could be made that by offering the job, you were implicitly promising that it would last more than a day, because who would have accepted a job that lasted only 1 day? You certainly wouldn't move under those circumstances. So that's an example of how promissory estoppel can play out. Let's talk about the topic of constructive discharge. This is something that comes up very often in employment discrimination cases. Sometimes the employee isn't dismissed at all, but resigns. Many times that employee, though, may say, well, the reason I resigned was because I really didn't have any choice. The working conditions were so horrific, I had to resign. In that situation, the employee is facing a bit of an uphill battle. It's certainly cleaner for him if he actually is dismissed. That way, there's no question. He was let go. But if he actually resigns or abandons his job, stops coming to work, then we'll need to look at it from two perspectives. The first question is, let's say that instead of the employee resigning, he actually had been fired. The employer had actually come in and said, you're out of here, we don't want your services anymore. Well, the question is, would that have been unlawful? If it would have been unlawful to dismiss him straight out, no questions, just absolutely say, you're gone. If that decision would have been lawful, then there's no problem with making the working conditions unpleasant so the person resigns on his own. But if it would have been unlawful to dismiss the worker, then the worker has satisfied the first element of the constructive discharge claim. The second element is whether the resignation was necessary. Were the working conditions really that horrific? So imagine for a second that I work as a teacher in a private school, and I teach third grade. And ordinarily, I get my lunch period from 12 to 12:30 off to enjoy eating my meals. And I am told, well, you can still eat your lunch, but you'll need to do it in the cafeteria. You'll need to supervise your class during the lunch period of time. And I say, well, I'm being constructively discharged. That is too onerous of a task for me to do. I need to have my lunch period off. Well, the court would say, well, I get that you don't want to work during your lunchtime, but that's hardly so severe that it counts as a constructive discharge. So even if it would have been unlawful for your school to dismiss you, it hasn't constructively discharged you because the conditions were not so awful that your resignation was reasonable under those circumstances. You're certainly entitled to resign whenever you want to. You're employed at will, but you can't complain about it and say successfully that it's constructive discharge under these facts. But let's change it up. Let's say that you're the private employer, third grade class, and the school says you are not going to be able to eat at all during your lunch period. And in fact, you are going to have to make the lunches for the children during that period of time and supervise them. And it just so happens that you are an insulin-dependent diabetic and you need to eat at set periods of time in order to manage your disease. And if you don't, you can have very serious health implications. And let's assume that the school knows about this medical fact about you. Well, in that situation, again, let's assume that the school would not have been able to dismiss you lawfully. Well, they really have put you in a position where your only option is to resign. You have been constructively discharged, so both of those conditions are satisfied in this scenario. Now, of course, the first one, you're going to have to point to some law that was violated. And again, we have to go back to the list that we talked about here, this list right here. So you have to find one of these being an exception. And so the dismissal would have to fit into one of these exceptions. It would probably fit into this exception most likely. So for example, let's say I have just married a person of a different race, and the school where I work has communicated to me they find that very offensive, and so they have communicated to me that they aren't happy with me. That would be discriminatory under Title VII, and so for them to fire me for that reason would be a very clear violation of Title VII. So in that situation, if they were to fire me, they would be liable under Title VII. But they're just smart enough to know, well, we can't fire her for that reason. We're just going to make things so unpleasant she's going to resign on her own. That's how the constructive discharge thing can play out. Now, sometimes what people think is they disregard this first one. They forget about it, and they say, my boss is making my life so miserable that I am being constructively discharged. I mean, that may be true. Maybe your boss really is trying to make your life so miserable that you're just going to quit. But that in and of itself is not unlawful. Keep in mind, with employment at will, the boss can just fire you. So there's nothing particularly, I mean, it's not very nice. I'm not defending the boss and saying that's a good thing to do, but it's not legally problematic that the boss is mean to you and that the boss wants you to resign. It's only when the boss would have been legally prohibited from dismissing you that the constructive discharge becomes legally significant. Okay, so here's a definition of constructive discharge. So another one to enter into Quizlet. This occurs when the employee has been given no reasonable alternative but to end the employment relationship. So it's an involuntary act on the part of the employee. For the employee to have a claim against the employer is necessary that would have been unlawful for the employer to dismiss the employee. So that's that element number 1. This one right here. This is element number 2. So let's consider the scenario. So Mary is working for this company. The company wants to fire her because she's a woman, but they know, hey, we can't do that. There's this Title VII thing. So they start putting unreasonable demands upon her. And it becomes very, very stressful, so she ultimately decides to quit her job. Now she's going to have to prove that she was put under a very, very great amount of stress. And it's a fairly high bar to get to that point. But if Mary can prove it, then she can prove constructive discharge. It is as if the company actually did dismiss her, and so therefore she can advance her Title VII claim. Courts often require the new burdens to be substantial in order for the constructive discharge claim to exist. And again, that's the standard in Texas. We have a case here. So just, again, having to work through your lunch, that's not going to cut it. But if it's very significant, then the courts are likely to say, yes, that can be constructive discharge. So as we think about employment at will, it's important to keep in mind that what I've said here today on these lectures is what the law says. But keep in mind that the jurors, the people who are going to hear these cases, are ordinary lay people. And when they hear, I mean, the judge will tell them what the law is, but many times when they hear that, they will think, I don't agree with that. That doesn't seem fair to me. I don't think that's the way things ought to be. And so many times juries will, what's called jury nullification, what they will do is they will apply their own sense of values and morality. And so they may end up siding with the plaintiff, not because they feel that the law as it currently exists means that the plaintiff ought to win, but they essentially rewrite the law so that there is an obligation. For example, the jurors would think, or many jurors would think, that an employer shouldn't fire somebody unless there is good cause. And many times jurors will put that burden on the employer. So employers shouldn't get too relieved by the fact that we have this employment at will doctrine. Yes, it exists. Yes, it does make it somewhat easier for employers to maneuver in the employment world. But at the end of the day, you may well be in front of jurors who don't really like the employment at will doctrine. So it's a good idea, if you're an HR professional or you're advising a corporation about how to proceed, is to assume that the corporation does need a good reason to dismiss them, a good cause, and to not support corporations making arbitrary or silly or foolish or mean decisions. As many times, even though they may lawfully be able to do that, the juries may well find some way to still nail the corporation for misconduct. If you have any questions about this material, please feel free to pop into my office hours. I would be delighted to talk about these issues in more detail. As always, I thank you for your attention, and I hope you have a wonderful day. Take care.